Hello guys, welcome back to Law Troop, and in today's video we will talk about the gist of the recent Supreme Court judgment running into more than 100 pages on the women's right to residence under the Protection of Women from Domestic Violence Act 2005, in short Domestic Violence or DV Act. So, on 15th of October 2020, the three-judge bench of the Supreme Court of India, comprising Justices Ashok Bhushan, R. Subhash Reddy, and M.R. Shah, passed a judgment in Satish Chandra Ahuja versus Sneha Ahuja, overruling its 2006 judgment in S.R. Bhatra versus Taruna Bhatra, which was delivered by the bench of Justices S.B. Sinha and M. Kataju, and declared that under the Protection of Women from Domestic Violence Act 2005, a wife is also entitled to claim a right to residence in a shared household belonging to relatives of the husband. Now let us briefly look at the facts of the case. The appellant, who is the father-in-law of the respondent, purchased a property in New Friends Colony, Delhi. After her marriage, the respondent started living in that property along with her husband. Now, the appellant, who was the original plaintiff, filed a suit against the respondent or the original defendant for mandatory and permanent injunction and also for recovery of damages or mean profits. Plaintiff, while referring to the interim order passed against him in the complaint case filed under the DV Act by the daughter-in-law, pleaded that the status of occupation of defendant as a daughter-in-law during the subsistence of a marriage with the son could be said to be permissive in nature, and defendant is not entitled to claim a right of residence against the plaintiff, that is her father-in-law, who has no obligation to maintain her during the lifetime of her husband. The defendant also referred to filing of complaint case under section 12 of the DV Act and claimed that the suit property is a shared household as per provisions of section 2S of the Act. The defendant has the right to stay or reside in the shared household. Thereafter, the plaintiff filed an application under Order 12, Rule 6 CPC on a particular date, read with section 151 CPC. Basically, Order 12 Rule 6 is about admissions, wherein if one party makes an admission, then the other party can ask the court to decree the suit in his favor on the basis of the admissions made by the other party, and they need not go into trial or proving their case because the other party has already admitted their case in the pleadings itself. So the plaintiff filed this application under Order 12 Rule 6 for passing a decree on the basis of admissions made by the defendant in the application under section 12 of Act 2005. Plaintiff pleaded that the defendant has herself in her pleadings filed in the domestic violence case admitted the plaintiff to be the owner of the suit property, hence decree of mandatory injunction in favor of the plaintiff be granted. Thereafter, the trial court decreed the suit in favor of the plaintiff. Now, the Delhi High Court opined that the real point of determination in the appeal is not as to whether the suit premises is a shared household or not, and while setting aside the trial court judgment, observed that the trial court had erroneously decreed the suit simply on the basis of the title without weighing the effect of the statutory right in favor of the daughter-in-law. So the present appeal is filed by Satish Chandra Ahuja, the plaintiff, questioning the judgment of the High Court relying upon the 2006 Bhatra judgment of the Supreme Court. One of the main questions which arises for determination in this appeal is whether definition of shared household under section 2S of the Protection of Women from Domestic Violence Act 2005 has to be read to mean that shared household can only be that household which is household of joint family or in which husband of the aggrieved person has a share. So the Supreme Court proceeded to note certain provisions of the Act such as section 2A, according to which aggrieved person means any person who is or has been in a domestic relationship with the respondent and who alleges to have been subjected to any kind of domestic violence by the respondent or the husband. Thereafter, while noticing the definition of shared household given under section 2s, it observes that the first condition to be fulfilled for a shared household is that person aggrieved lives or at any stage has lived in a domestic relationship. Further, the court also observed that the definition of shared household given in section 2s cannot be read to mean that shared household can only be that household which is household of the joint family of which husband is a member or in which husband of the aggrieved person has a share. The court also further opined that the interpretation of definition of shared household in S.R. Bhatra versus Taruna Bhatra is not correct interpretation and the said judgment does not lay down the correct law. So the conclusion is that a woman can claim right to residence and the property owned by relatives of her husband or in-laws if she and her husband live there with some permanency after marriage. That is it, guys. In today's video, the court had referred to various previous judgments and it was a really detailed discussion. So if you want to learn about all of them, then please go through the whole judgment on the Supreme Court's website. In the future, I'll try to have a more exhaustive video on the judgments because I found it a bit confusing to add all the details in one video. However, it makes more sense if it's more complete rather than it's more confusing. So thank you and please like, share and subscribe to the channel.